Welcome to the Bob O Show. My name is Bob Potzner. I'm an attorney with the law firm of Collins and Hannafin PC. I'm also a member of the Connecticut Bar Association, and I tell you all that because today's show is going to be a very interesting one, in my opinion. It's about the 2024-2025 high school mock trial procedure that's going on right now, sponsored by the Connecticut Bar Association. And I have two gentlemen, Steve Sedensky and Jonathan Weiner, who are actively involved in the program. And we're going to talk today about what is the mock trial, how does it work, why is it done, and how does it proceed. It's, I think, a wonderful activity. I actually, many years ago, coached, when I used to live in Shelton, Connecticut, I coached the Shelton mock trial team for many years. And I have this year been honored to be a judge in the Danbury Regional Mock Trial Competition on January 9th of 25. So we're going to talk about the program, how the kids get involved and what they learn and what we as the judges learn as well. So Steve, Jonathan, welcome.
Thanks, Bob. Hi, Bob. Nice to be with you. Thanks for inviting us.
It's my pleasure. And Steve, why don't you start out by telling us a little bit about what the program is, and then we'll go into Jonathan. Tell about yourself. Tell about yourself first, who you are and what you do, and then we'll get to the program second.
Okay. Well, I'm the retired state's attorney for the Judicial District of Danbury, which includes Danbury, Newtown, Reading, Ridgefield, Brookfield, there's New Fairfield and Sherman. And I got involved in mock, and which means I'm a prosecutor, and that's the equivalent of the district attorney in other states. I got involved in mock trial back in 2014 when my daughter was a freshman at Immaculate High School, and had done mock trial in grammar school, and Immaculate did not have a mock trial program, so I agreed to do it, and I did it for 6 years, and then the person who was running the Danbury program for the running the competition in the courthouse, Attorney Wendy Grispin, went on to the bench and became a judge, and so I agreed to take it over 3 years ago, and so I've been running the Danbury program since Judge Grispin went on the bench.
And I should say that Steve, who's being very humble, he is a very highly respected and was very highly respected in his position as a DA. And although I don't do criminal law, there were occasions where in my cases I needed to talk to Steve for information, and he was a plethora of knowledge. And so I really appreciate his being in the program and being on the show today. Jonathan, how about you?
So, Bobby, thanks for having us on the show. Really appreciate your taking the time to invite Steve and I to appear and discuss the mock trial program. For my day job, I'm an attorney and permanent law clerk at the State Supreme Court in Hartford, where we're the state's highest court, and we address all manner of civil and criminal appeals. And so I work directly with the justices on researching and drafting the decisions. Outside the office, one of my activities is I'm the co-chair of the Connecticut Bar Association Civics Education Committee, and I'm also the chair of the mock trial program. The CBA Civics Education Committee superintends most of the public education offerings of the Connecticut Bar Association, where we provide really one-stop shopping to teach school students about the rule of law, civics, and both public speaking and professionalism. And we provide programs at all age ranges from elementary to high school, but the high school mock trial program really is our flagship, and we're very proud of it, and we're very proud to now host this program and offer it to the entire state. So thanks for having me on.
Jonathan, you mentioned the word civics, and I think I was on the Board of Education for 15 years, 9 years when I lived in Shelton and 6 years when I was in Richfield. And I think one of the most important courses kids take is American history and civics. And I think too many, in my humble opinion, or maybe not so humble opinion, too many kids get through high school and college not knowing civics. I think it's a very important part, and we're seeing it now in our elections. It's very important to know that. The other comment I want to make is I want to give credit to the CBA Civics Education Committee mock trial subcommittee, and that consisted of Judge Craig, Attorney Jeannie Dumont, Judge Hope Seeley, yourself, Jonathan, and Attorney Mark Youssef. I want to give them credit for what they have done in this program. Can you tell me, please, Steve, briefly, what is the mission of this mock trial program? if it has one. I think you're on mute, maybe.
Yeah, John might be better on that, but I mean, from my standpoint, is to introduce the students who are at the high school level to what actually goes on in our courtrooms in contested cases, and they take the roles of attorneys who are presenting these contested cases to a court, and they learn to think on their feet, and they learn to be witnesses. And so it really introduces them to the actual nuts and bolts of the court system. So that's kind of how I see it as the purpose. And they come away with public speaking skills that they may not otherwise get a chance to learn.
Jonathan, do you want to add to that on the mission?
Well, I would certainly agree with that in terms of providing an introductory deep dive into the legal system. And I think as you can see by judging the competitions, the students, especially the attorneys, become so comfortable with the rules of evidence that they could stand on their own with many practicing attorneys in terms of how comfortable they are with articulating things like hearsay, and the various exceptions to the hearsay rule. And really, it's also not to give short shrift to the witnesses as well. The witnesses spend a lot of time. Their performances are ranked equally to the attorneys, and without them, the entire process doesn't happen. And again, beyond the public speaking aspect of it, we also are emphasizing the importance of civility and professionalism, and we want to make sure that students understand that there's two sides to every issue, and the problems are drafted to be competitively balanced so that either side could win at any time. And we want to make sure the students understand that there's two different sides, and you have to understand both sides of any potential issue before you're really comfortable coming to a conclusion on it. And we require them to do that, and that every team has to be both prosecution and defense in any given trial, and they have to present both sides multiple times throughout the competition.
I think one thing there are a lot of things I thought were terrific, but the case that I judged with Judge Sadi, so Judge Sadi is a real judge. I was just an attorney playing the role as judge, but both teams have, as you said, a prosecution and defense side, and the ones who were not performing in the case that I saw were in the audience watching. And that's very important, because I think you guys would both agree with me. When we were young lawyers, even when I got to be an old lawyer, if I'm in court, I would go watch certain cases, because you can learn something every time you're in court. And especially if there were certain lawyers who I knew had a trial, I might watch it. One of the difficulties of COVID, however, is that probably not so much in the criminal division, but in this litigation division, a lot of things happen outside the courtroom. And so young lawyers don't have the opportunity to watch and learn from others. And I was watching, when I was making rulings with Judge Sadi about objections, et cetera, the students in the audience were watching as closely as those performing, because they were watching and learning. Do you have any comments about that, gentlemen?
Oh, I think that's actually, as you said, Bob, typical of real life, that you can learn so much by watching other lawyers go through the court process of a particular trial. For the students, I think it's particularly helpful, because they may see that same issue come up and wonder to themselves, well, gee, the judge that I had handled it a little differently. And it really forces them to think on their feet, because not every judge will look at the evidence the same. So it's very important to watch other lawyers, both from learning about the judges and learning how the practice actually works.
It's funny it's ironic you said that, Steve, because there are different judges in the court system in Danbury, for example. And if you have a trial, you may not know who your judge is going to be even until the day of the trial. It happens that way. And I serve as a special master in the divorce area, in which 4 times a year we volunteer and listen to other people's cases, and we try to help them with their lawyers to resolve the cases. And we'll say, well, you could have judge A, B, or C, and we don't know which judge you're going to get. And I don't know what the judge is going to say, but here's what I think. Jonathan, thoughts about that?
Well, that's actually an issue that comes up all the time, especially in the newer programs, where teachers will come in and say, my morning judge did it this way, my afternoon judge did it this way, did it another way, and what's correct? And my kids can't adjust. And can you fix this problem? And really the answer to that is, it's not a problem. It's how it happens in real life. And judges, judges will rule, different ways on the same issue. Judges have different practices, and you have to be able to adjust to that on your feet. And what we're seeing is that the better mock trial teams, through experience, can adjust to that, and they can accommodate to any manner of judging styles. And what's interesting is, I know you mentioned judging with Judge Sadi. A lot of times we'll have one volunteer handle the prosecution side of the case and another one handle the defense side, while their partner just sits back and watches and scores. And so sometimes even within the same trial, they've got to make adjustments. So it's a really good experience for them in terms of thinking on their feet, and sort of reading the room and figuring out, well, what does this judge want to hear from me, and how does this judge want me to present?
I will say that when Judge Sadi and I were ruling objections, he was kind enough to bring me involved in decisions, and there was not one decision that we made in objections that we differed on. And we didn't plan it that way. It just happened that way. Another thing I want to say is I'm just finishing up a 44-day trial, and a judge had a favorite expression, which was, he said, I'm not always right, but I have the last word. I'm not always right, but I have the last word. And we as lawyers have to accept that it can happen. Same fact pattern may have a different ruling by the judge, and that's where you have to just adapt to how you're going to proceed. Who wants to take the question of how the case, in the case that I judge, was called State of Connecticut versus Emerson Harkness, and those are, the State of Connecticut's a real name, but Harkness was a pseudonym. Tell us a little bit about how the case fact pattern came about. Who wants to handle that?
I'll handle that one. So, as part of the mock trial process, we belong to an organization called the National High School Mock Trial Championship. And ultimately, our state champion, after our upcoming playoff rounds, is going to represent us in the National High School Mock Trial Championship that takes place this year in May in Phoenix, Arizona. Part of that membership, we receive access to a case bank, and we get access to cases from all around the country, most of which have been vetted for balance and for content. And what our committee typically does is we'll review a few cases over the summer, and we'll kick around a few ideas and decide what kind of theme do we want to have for the year. We're always looking for something timely. So last year, for example, we did a dispute in a contract case coming out of a COVID wedding and all the accommodations that had to be made to have a wedding safely during COVID. But it turns out that the kids really like criminal cases more than contract disputes. So this year we chose State versus Emerson Harkness, which evolved from a dispute between bar owners somewhere in a fictional place near Pennsylvania to the town of Rocky Neck, Connecticut. We always try and make the cases relevant to the kids, both in terms of content and location. For the most part, we'll use fictional locations, but really for all the Easter eggs and all the fun stuff that's in the problem, I have to give full credit to Judge Hope Seeley, because after the committee meets and selects the case, she takes the draft, disappears for a month, and then comes back with a finished product that we then review and publish. And none of these cases could happen without all the work that Judge Seeley puts in on behalf of the committee.
Jonathan, you're making me smile, because when you mentioned the COVID wedding case, I'm in my house right now in Richfield, Connecticut, and my daughter was supposed to get married in a very nice wedding in Madison, Connecticut, but because of COVID, we had to shift the wedding to our front yard, and we only invited 13 people. It was right in the heart of COVID in 2020, and the wedding was in our front yard with a homemade chuppah. So you did pick a fact pattern that really hits home to me. Thank you for mentioning that.
You would have loved judging last year. I'll send you a copy of the case, but it took place at a venue modeled after the Goodspeed Opera House, and overlooking the Connecticut River. The only minor issue was that the people were forced to have their wedding cut down from, I think, 500 people to about 100, but the cost didn't change all that much. And so that was really the nub of the dispute, and all of the various accommodations that the historic venue might need to put in. And it was interesting to see the kids argue about it, but the reality is they love the murder of State versus Harkness.
It's also another funny thing, and these other patterns come up. I had someone who wanted me to bring a case because their wedding happened, but the power went out before the fancy desserts came out, and they wanted me to file a suit. And I said, you know what? Just go on with your life and have a good marriage. Let's not argue about it. But I do tell people, when you pick a wedding venue, make sure you have a place with a generator. Steve, would you please tell us, how do the kids prepare? What's the process once the case fact pattern comes to them, what's the preparation process like?
So in terms of, every school does it. Every school probably does a little variation on this, but they really, as soon as when school gets back in session, the kids are notified that there will be a tryout for a mock trial, and depending on the number of students that try out will determine the number of teams that a particular school has, including how many volunteers that they have to coach the students. So once that is done, and we try to be as inclusive as possible, and if we have enough for 2 teams, we'll have 2 teams if we can get the volunteers to coach them. And then the actual packet that John just talked about is then, once that's made available, we give that, that gets sent out to the students to prepare for, and we then look to see what we have in terms of the students and in terms of assigning roles to the student. And the nice thing about the packets are, any gender can play any particular role of the witnesses. It's written in such a way that one person doesn't have to be a male or have to be a female, which is good, so that everyone gets a chance to be a particular type of witness. So they start essentially in September working on the case, going over it. Most times that first couple of weeks will just be analyzing the case and going over things like, what theme do you want to have, and breaking the teams up into prosecution and defense, going over the themes for the defense, themes for the prosecution, and then little by little starting to develop opening statements, examination of witnesses, and it progresses through September, October, November, and then December is when the competition starts. Danbury typically holds their competition in the first couple of weeks of Danbury. First couple of weeks of December. Here we had December 5th, but we had to cancel it because of the weather situation. Fortunately, the courthouse, Judge Medina and Chief Clerk Ann Margaret Archer were able to get us a rescheduling date of January 9th. But the kids are working solidly, depending on the school, at least once a week. And as it gets closer, twice a week after school is when I know Immaculate does theirs, after school for several hours. And then in their off time, when they're not meeting, they're working on, refining their direct examinations, their cross examinations, and their opening and closing statements.
And the other thing is that not only do the students work hard, the judges worked hard. This is my trial notebook that I had put together, and every single judge, when I judged the afternoon session of the date that we had, every single lawyer, judge, and actual judge had some kind of packet like this, consisting of the laws that were applicable, the fact pattern, the documents that would have been the exhibits. And I would say I spent about 3 to 5 hours preparing for the judging, and the others who are judged with me did the same kind of activity. So we take it seriously because we as the judges want to make sure that the students are getting a fair shake, and we're not just like walking in. And typically when you go to trial, most good judges, and all that I've seen, have done preparation. They don't just walk in typically not having seen the file. The other thing I want to say is, as part of the judging, you can't see it now, but I have a sheet here, and I was given as a judge the things that we should consider in what the students do. So it's not just Bob Potts saying, well, this is what I would do, this is what I wouldn't do. This is an actual thing that we look at to read to make sure we're having consistent judging. And I think that's very important. Jonathan, any comments about having that consistency in the judging process?
Consistency is extremely important because it helps the kids prepare. I know we talked about some of the idiosyncrasies between various judging styles before, and of course, not every judge, not every judge sees the cases or personal styles differently. I know we've had teams that have extremely dramatic styles. We also have teams that have, what I would call somewhat more buttoned up professional styles in terms of how they present, and their substantive knowledge and ability might be the same. It's just a different presentation style. So there's a lot of subjectivity there. even within the criteria that we provide. It's one of the reasons that we like having multiple judges per room, because having multiple judges per room eliminates some of the biases and subjectivity that do go along with the objective criteria that we give to the students. So it really is the more the merrier when it comes to judging the trials, because we want to make sure that those objective criteria are applied in a way that leads the kids and their coaches to believe that the best team truly did win.
Jonathan, you made an important point, and that is that good trial lawyers, and I hope that I'm considered to be a good trial lawyer, I think I am, we all have a different style. And Steve might try a case differently than I would try the case, or Jonathan might try a case. And when people ask me, well, how should I do this or how should I do that? I'll tell people who are young lawyers or even mature lawyers, what I think, but then I say, but you're not Bob Opotzner. You are Sam Smith, Sandy Jones, whatever your name is. And you got to do what you're going to do, because if you try to be Clarence Darrow, you'll never do that appropriately. You've got to be your own person. And that's why these kids, as they watch and learn, it's important. We, after our trial, Judge Sadi and I reserved about 10 or 15 minutes at the end of the trial to tell the kids what we thought they could learn about. For example, I made a comment that one of the witnesses particularly every so often looked at the judges. And that's something I tell my clients and my witnesses, look at the judge to make a viewpoint. I made some comments about reacting to an objection that is, if you make an objection and it's overruled or sustained, sustained means that it doesn't go, it's overruled, then the person gets to answer the question. Sustained means it doesn't get answered. But I talked about, one situation happened where a person just said, okay, instead of trying to nicely, politely, judge, may I make more comment? So that was, I think, really important. Steve, do you have any thoughts about what we tell the kids after the trial before the grading comes in? You're on mute.
I think that's very important to at least give the kids some feedback after the trial. But even more important are the written comments that get provided by the judges and are part of the score sheet, because they do. I think right after the trial, oftentimes things that are said to them aren't necessarily retained, and that just because they're kind of relieved it's over. It's been a busy day. And they've been there for 2.5, 3 hours, so that while they certainly appreciate the comments afterwards, I think it's the written comments that they really then take home and go over them, and we provide them to all the coaches that the judges have filled out.
And by the way, when we made the comments, we never said, Johnny or Sally or Susie, this is what you did right or wrong. We did it sort of as an overall general perspective, and the hope is that the team that wins, or the teams that win, will learn so they do a better job. I'm actually going to be judging in Bridgeport on February 7th, and it will be a probably more sophisticated presentation by each team, because they will have seen what they did right and what worked and what didn't work. And it comments about the learning process, Jonathan, as they go on to different rounds.
As really an observer, as the event organizer, I'm not involved with coaching specific teams. I'll step in and judge if we need an extra judge in a room, and I always value the opportunities to do that. But I always think it's very interesting to watch how things progress from December with the regional rounds, where we have 56 teams across the state, to then into February, where we have 20 teams competing, and then ultimately we're going to be down to 8 teams on March 7th in Middletown, with the next stop being the finals before the Supreme Court. And so, although it's the same case, you see it presented so many different ways, and all of those details really start to shine through as the presentations evolve. So I think you're going to enjoy judging in Bridgeport so much on February 7th. You're going to want to come back and see us in Middletown on March 7th, because it's fascinating to see the development of things. And then really, by the time the teams start on March 7th, any one of those 8 teams could go on to be our state champion and represent us in the nationals.
One thing that's on the list, we only have about 3 or 4 minutes left. I told you the show goes quickly. The issue of civility and professionalism. And I think that's a very important part of what you're teaching as the program goes on, and plus what the coaches do, because our society right now doesn't have civility like it did when I was younger. And that's something we have to work on. But in the court process where the rule of law applies, you got to be civil, and you got to take your wins, because you're not going to win every single case. We all can't be Steve Sudensky, who wins every case, right? But there's going to be a time where a judge rules against you and whatever. And judge, I have the case right here. It supports my position. And you got to learn to say, thank you, judge, and go on. Talk about the civility issue, Steve.
Yeah. I first of all, my experience with the kids has over the years, and the schools that I've been involved with have always been very, very, very civil on it. And I think it's something that gets stressed to them. Every now and then, especially when I was coaching, you'd get somebody who maybe watched some TV show, and where the lawyers involved or the witness involved, particularly the lawyers involved, came across as antagonistic. And it's so important for them to know that that doesn't win cases in front of a jury. That oftentimes basically goes to their detriment, both in front of the jury and in front of the judge who has to make the decisions. So I think that learning process of being civil to, but not only to the court, but also to opposing counsel is one of the great lessons that they learn in the program.
Jonathan, any comment on that, especially about this? It's not only civility to the judges, the court staff, the court clerks are critical to the process. And when I saw one of the cases going on with our president-elect, and I saw that a clerk was getting attacked, I have never in my career ever seen a court clerk be criticized. I mean, you might disagree with them, but you have to show the same respect to the court clerk. We have 30 seconds left. Jonathan, quick comment about that, please.
No, I would agree with that. I mean, the court staff are certainly an indispensable part of the process, and that's everybody who's involved, including the marshals who keep, who protect the buildings and keep everybody safe, to the court clerks, and all the way to to the research and staff attorneys who help the judges. So it is bad enough to see judges be attacked, and I personally view that as an attack on the rule of law. But to me, it was actually beyond the pale to see court staff and civil servants be attacked for their roles in assisting the judge.
Jonathan, I will just say this. One time I was in court, and the other party, as I was walking away, apparently was coming at me. I didn't see it. And the marshal, before I saw anything at all, got between that person and me. And I never saw the whole situation. The staff is critical. Steve, Jonathan, I'm sorry the show went so quickly, but it went quickly because you guys are so good at what you do. And I want to thank you very much for your role and inviting me to be involved in the program. Thank you very much. This has been Bob O'Potzner on The Bobby O Show. Have a great day.
Bob, thanks for having us.
My pleasure. Thank you.